Ask you to take this instance. Okay, folks, you're all very welcome to the atrium this morning. For those who don't know me, my name is Jonathan Sullivan. I'm the Acting Deputy Secretary General on the civil side of the department, and in that capacity, I'm very pleased to be the chair of the Family Justice Implementation Group. Thank you really sincerely for taking the time to join us here today. It's also a pleasure to have our Minister with us today to lead out on this first meeting of the Family Justice Development Forum. I guess just to set the scene, in our role on the implementation group, which I chair, we're charged under the strategy with ensuring the delivery of the actions under the strategy at a detail level. That group is made up of the agencies who are all individually charged and collectively with those actions. So, our department, the court service, the legal aid board, representatives of the county registrars, the Department of Children, and we're doing really good work, which we'll be updating you about today. But I think, as you all know, we also thought it was really important under the strategy that we could establish in parallel and to complement that group this consultative forum so that we could continue to ensure, just in the way that I suppose during the course of this development of the strategy, we benefit greatly from your insight and your advice. It's really important that we continue to get your input and feedback as we roll out implementation of this complex and ambitious strategy. And that very much reflects the varied and important work that everyone in this room does, not least, in fact, in working with families as they navigate our family justice system, often at very difficult and vulnerable periods in their lives. As I think you know, as envisaged under the strategy, the idea of this forum today, I suppose, kind of broadly speaking, twofold. One is to provide you updates on progress and implementation, answer questions, and to tease out some issues, but also very importantly to continue to gather feedback on and engage on detailed issues. So there will be some work for you to do today as well, I'm afraid. Just to give you a general sense of the plan for this morning's work, I'll hand over shortly to the Minister, who will update you on the work to date and planned, following which the Minister will also be staying with us to participate in a panel discussion and Q&A. To join on the panel, our panel members are here this morning. Again, representatives of all the key agencies involved in delivery of the strategy, Joe Crawford, the Legal Aid Board, Angela Denning, the Court Service, Judge Paul Kelly, President of the District Court, Alvin McGovern from DCD, and myself. Following the panel discussion and Q&A, we'll have an opportunity for some coffee, and then we'll be proceeding with some breakout work in the second half this morning. And the focus there will be on the development of child-friendly information. So I guess the key strand, obviously, in the strategy is the role and rights of the child, and how is the child to be able to communicate in the process they can understand that process. Our department has an action to lead on developing that action. This autumn, so we're very keen to get your early input on that strand of the work. That session will be co-facilitated by Liam Cohen from the department and Julia O'Hara from the Children Rights Alliance, so we're very pleased to have that input. And then finally this morning, Liam will wrap up things and attempt to draw together our work for the morning in a succinct way and set out some next steps. And hopefully some people can stay with us for coffee and sandwich afterwards. One final important piece of information, piece of housekeeping, I guess. We are recording the first part of this morning's session for use on our LinkedIn channel, so hello everybody on LinkedIn. When we get to the break and the breakout session, we will cease recording that. So that's it. Look forward to our work across the morning today. Hope to get to chat to more of you individually over the course of the morning and beyond that. And now I'll hand over to our Minister, Mr. Cavan. Thank you very much.
Good morning, ladies and gentlemen. You're all very welcome to the Department of Justice and indeed to those who are joining us online. And thank you to our panel of speakers and those who are participating. Though indeed, as Sonika said, I think everybody is participating in the work today. What's really, I think, important about today and what's really special about today is that each and every one of you, every single person in this room, we are absolutely united in what it is that we are trying to achieve. As Donica has rightly said, we're trying to make sure that for families, that for parents, that for children who are going through what is often the most difficult experience or time in their life, that we in some way make that little bit easier. While we can't change the fact that it will always be a difficult process, we need to try and make it that little bit easier. And I come from from two ways. I suppose I have seen people who are closest to me go through awful situations. Some of our children have been involved, and it takes decades to right some of the wrongs and some of the issues that can arise in what can be a very adversarial situation. But also from my own work as a TD. I'm a minister, but I've been a TD for 10 years, and I see day in, day out people coming into my office where they face challenges through the family justice system. And I think everybody here can probably apply that same approach. You see things in your own personal life, but you see things in your work every day. What I'm really clear is that there are fantastic people, many of whom are in this room, working day in, day out to achieve that goal, to support families, to protect those who are vulnerable, to make sure that we make what is a difficult situation a little bit easier. But what's really clear also is that the structures, the physical built environment and the supports don't align and aren't there. And that's really why we're here. And I think through the Family Justice Strategy, through the Family Courts Bill, that is how we are going to, working together, actually make that change and make sure that both of those areas align. As you know, I published the Family Justice Strategy, the first one back in November of 2022, and the commitment in that was to have this forum. So while we have our implementation group and while we're working ahead with many of the actions, it's to make sure that we come together, many of you who have been instrumental in actually developing that strategy, that I can update you, tell you what work we're doing, what's happening, that we can listen and get feedback from you, that we can engage with each other, that we can continue to learn from each other. And that will be a continuous theme throughout all of this, which will be a lengthy process. This isn't going to happen overnight, but I think we all can see that, and I think we all subscribe to that. Before I start, maybe just in that regard, I really do want to thank people for their input to date. For everybody who has taken part in the consultations, who helped form the strategy, to our oversight group, for their hard work and commitment, and to those who are now working, I suppose, in the monitoring and oversight role as well, for that continued commitment. As I said, this is going to be a lengthy process, but the fact that there are so many people committed to it really is wonderful to see, and I just want to personally say thank you to each and every one of you for that. As I've said, maybe I just want to go through some of the areas that we have begun work, areas that I think are important, and obviously I won't touch on everything, but there will be discussion throughout the morning to develop some of these areas and to further discuss them. Firstly, around child maintenance orders, and when I mentioned that in my constituency office, I see issues arising all the time. This is an area that has consistently been brought to my attention, in particular enforcement of maintenance orders, not just because of the financial burden that it places on individuals who are, again, having gone through a very difficult breakup, but also it can be used as a way to continue abuse, continue control through the courts, and it's something that we need to try and address. So the review follows on from other considerations that have been I suppose looked at, and recommendations from the report of the Child Maintenance Review Group, but specifically on that issue, I'm told to have recommendations in the third quarter this year that we'll be able to look and assess and hopefully bring forward. Two significant reforms that came out of the Child Maintenance Review Group, particularly focus on how we can support vulnerable families, that we can support and address the issue of child poverty, but also look at issues that primarily impact on women in this situation. So looking firstly that we would no longer include or consider child maintenance payments in means test for social welfare payments. And what that automatically means is that people who are on lesser payments will see an increase, but also those who don't meet the threshold or who aren't qualified at the moment, that they will actually be qualified. And again, I think it takes away, I suppose, a challenge that many are facing. Secondly, that no parents no longer would have to actively seek maintenance to be eligible for such payments. Again, taking away that stress of having to go to court for somebody who is going through a very difficult situation to start with. The review of the enforcement of child maintenance orders, as I've said, I think will be absolutely vital for so many parents in this situation. So the sooner that we can get recommendations on that, the sooner we can move, the better. Second, looking at a number of areas, some of which had already started before this strategy was put in place. Firstly, parental alienation, again, a concept or an issue that has been brought to my attention time and time again. We had begun work prior to the strategy's publication with the Commission of Research on the topic. We had consultations, we had a huge amount of engagement, and again, to thank organisations here who took part in that consultation. And I think the submissions really helped inform the final policy paper that was produced only a few weeks ago. The paper puts forward 6 recommendations, which I won't get into because I think anybody who's engaged would I suppose, know what they are. But what I will say is that despite the highly contested nature of this, I think there was general agreement that the best way to deal with parental alienation is through the reforms that are set out in the Family Justice Strategy, by improving access to the courts, by improving the supports, by improving the structures, and making sure that we have very clear supports and clear guidelines in place for children. So making sure that we have robust mechanisms to protect children's constitutional rights, that they are heard no matter what the circumstances, where it is an issue that impacts on them, but also that they are at the centre of the family justice reforms. And that's something that is absolutely critical to the strategy itself, that will place children for the first time at the very centre of everything that we are doing here. Secondly, looking at expert reports. This is an area really that is unregulated, that needs to be regulated, we need rules, we need guidance, and we need to make sure that anybody who's providing an expert report to the court, that there are very clear guidelines and rules as to how they operate, and that's clearly set out. So this is an area that I actually asked my officials to work on and to commence earlier than was set out in the strategy. That work is underway, and I really do expect a set of recommendations this year in the earlier part when we return after the summer recess. Looking at then again the voice of the child, specifically looking at in-camera rules and other priority actions as well. You will see, and Donica has mentioned on the agenda, we have a breakout session for later this morning where we will be seeking more input, specifically looking at how we can communicate with children in the best way possible. And speaking with Julie there and Liam, I think we were saying if the child can understand it, the parent can understand it, so everybody wins in that regard. But I just want to thank the Children's Rights Alliance and Margaret and Julie who are here to help us coordinate that particular session. But this comes from the fact that when we had a bespoke child consultation, what came out very clearly is that young people want information in a timely manner, in a way that's accessible to them, and in a language that they can understand. And the plan in the strategy is that we would have work done on this, again, commencing in Q3, so a lot of stuff happening around that time, but to be able to get your feed and your input into that, I think, will make sure that we get the ground running and make sure that we get what is such an important recommendation and at the core of what we're trying to achieve here, that we get it right. On the in-camera rule, as I mentioned, my department is going to begin a piece of work shortly, looking at the in-camera rule, looking at how it's currently applied, its current operation, particularly around research, looking at reporting of family law cases. I know that it's been opened up in the past recently when we're looking at research, but how do we make sure that again, and this is feedback that we would have received from many of the organisations working on domestic, sexual and gender-based violence, that it's not used as a way to keep things in secret, or that we acknowledge that there is that interface between the criminal process and the civil process as well. So we'll be doing a piece of work on that, again making sure that the actions are produced and that we have a report on that as quickly as possible. Other areas then just that are being worked on, setting up a group of the main stakeholders. This includes the Department, the Court Service, the Legal Aid Board, NGOs, when required, to try and better communicate with the public about what we're doing. So we can do all of this, but we need to make sure we tell people what we're doing and what it essentially means for them. That we have a regular cross-functional communication group to manage communications with the public, but also stakeholders and the family justice system. And then we are establishing a working group to look at data. So it's one thing that I think is a common theme across the justice sector, that we need more data. We need to gather more data, whether it's domestic, sexual and gender-based violence, whether it's particular types of crimes that you're reporting, whether it's family justice matters. We need data to be able to inform and to correct how things are improving, as well as how we need to use it to implement our policy. The family justice strategy obviously aims to improve outcomes for family overall. There's probably more focus when it comes to private family law, but there are other matters that also relate to public childcare, and in that regard my colleague Minister O'Gorman would have issued a publication recently that was findings from 10 years of reporting on judicial child care proceedings by the Child Law Reporting Project, and I have no doubt that that will feed into the work that we're doing. But what we are proposing to do in this strategy is to explore establishing a family law reporting project to try and further our understanding of family law, and again this will feed into the work that we're doing here. I mentioned domestic, sexual and gender-based violence because very hard to talk about the two in silent. They are inextricably linked, and the challenges that families face. It can be an extremely difficult period in someone's life where you add to that abuse, not just of a parent but also of a child. It makes a difficult situation even worse. So we need to make sure that everything that we do in the family justice system, that we're providing the right supports, that we're providing the right resources, that we make sure that where people are sometimes involved in consecutive or concurrent criminal and civil proceedings, that there is that connection between the two, which doesn't exist at the moment. People are having to relive traumatic experiences, and where the two arms are not talking to each other. This again is something that time and time again has come to my attention, and I know everybody in this room. So in addition to the in-camera issue, which I've already mentioned, an important action in the strategy is to consider other findings and recommendations of the research, exploring that interface between the civil and the criminal interaction and the childcare process as well, not forgetting that is inextricably linked. And again, work is underway on that already. Through the People Development Goal, and I'm delighted with members here from the Judicial Council who are involved in the training side of things, education absolutely key, and the Supporting a Victim's Journey plan that was developed as the first strategy that I worked on here around domestic, sexual and gender-based violence. Training was key, making sure that any person that a victim or a person going through the family justice system comes into contact with, that they are trained to understand, to have trauma-informed skills, that they're empathetic, that they are responsive to the needs of all of those who are going through the system. So it's a huge focus and priority, and again, just to acknowledge that work has already begun, and it's how do we make sure that it is in place for everybody and that everybody avails of this kind of training and have that type of knowledge, particularly those that are going to be managing our family courts, and so focus and priority will be in the area of family law. The strategy that we're talking about today is inextricably linked to the zero tolerance strategy, and that is our domestic violence strategy. It also, as I said, helps to progress the recommendations in supporting a victim's journey, which really focuses on protecting vulnerable witnesses and victims as they go through the criminal justice system. We have made progress in those areas already. We have the first cohort of staff at the new Sexual Offences Office in the DPP. We have advanced training, as I've mentioned already, for those working in that space. We have introduced preliminary trial hearings, which I really do hope will make, again, a difficult situation for someone who is a victim of sexual assault or rape to take some of the challenging environment out of the court system and to deal with it before the case starts. But also it's about changing attitudes, it's about changing hearts, it's about changing minds, it's about educating our young people, it's about trying to prevent abuse from happening, and for that then being brought into the courts and in other places as well. And in that regard, we have a huge amount of legislation that's being progressed at the moment. In fact, I'm in the Chambers later on this afternoon bringing forward the Criminal Miscellaneous Bill, which will put on a statutory footing strangulation or non-fatal strangulation and stalking, which will essentially increase our maximum sentence for assault causing harm from 5 to 10 years, but also the Sexual Offences Bill, which is going to be introduced in a number of weeks again, which focuses on consent, which makes other reforms and changes that will support victims of domestic, sexual and gender-based violence. And the reason that I say all of this is, as I've said at the outset, these two strategies are inextricably linked, because you have many people who find themselves going through a breakup who are also victims of these horrendous crimes, and we need to make sure that there is that continuous engagement and understanding on both sides of what an individual, what children are going through as well. Of course, we can't do this without resources. We can talk about all of this, but if we don't have the structures in place, as I said at the outset, it won't work. A really important report that was published earlier this year was the Judicial Working Group, looking at the number of judges we have, types of judges, where we need to increase our numbers, where we can have efficiencies, and how we can bring this all together. And I'm really pleased that my colleagues published this, but also Cabinet agreed to increase the overall numbers. An initial increase of 24 judges were approved, and I know the President here and many others obviously are looking forward to seeing those filtering down through. But we have already made initial appointments, and I intend to bring more appointments before the summer is out, that will ensure that every single course sees the benefit of that increase, but that we continue to make those increases so that the access to justice piece can be dealt with, and obviously that the pressure that is there, that I I know that is on our judiciary, that we relieve that in whatever way that we can. Of course, the infrastructure is a key part as well, making sure that we have a family court structure that is welcoming and that is not a case that we have taken at the end of a very long day where there isn't the time and there isn't the ability to give it the attention and the priority that it deserves and that it needs. And I say that acknowledging that obviously every individual case needs the focus and the priority that it deserves, but we're dealing with extremely difficult personal situations. So my goal is that we would enable a family law environment where cases are dealt with more quickly, where it's in a less stressful environment, where cases are held either on different days or in different buildings or different parts of the building to other hearings that are happening, and that of course would be progressed through the Family Courts Bill, which is being worked through at the moment, and again which I hope to have enacted as quickly as possible. We need investment as well, so there is a commitment. Overall, the capital budget for this department is 270 million. So while that's not solely focused on our courts buildings, a huge amount of money will be invested in developing our court structures, not least Canon Lane, which I know is long overdue. We have a very fragmented and inadequate system, I think, for families in Dublin, and that will bring all of these structures together and make sure that we have a family court that is family friendly at the end of the day. And again, that is a project that I'm pushing to have commenced as quickly as possible, and obviously once that work starts, that we close it off as quickly as possible. Finally, just one other area maybe to touch on, because it's an issue and it goes right back to the issue of child maintenance, and that is ensuring that people have the ability, if they have to go to court, to have legal representation. And what we've seen in the feedback is that so many of those who apply for civil legal aid, it is because of a family law matter. Many don't meet the threshold. So we have our first review of civil law, the civil legal aid happening at the moment, and there is a specific recommendation in this looking at family law and how we can potentially support more people who need that kind of support. And again, that's been progressed through this separate action, and I expect it to report later on this year. So there's a lot, I could go through many more. As you can see, there's a lot of work there's a lot of work underway. There is real commitment, and there's a lot of my team here and members of the Department of Justice who are really committed to this for all of the reasons that I've outlined at the outset. And for me, if you ask what does success look like, we're being very ambitious in what we're trying to do here. We have to be. We don't have another option as far as I'm concerned. But we are laying the foundations. We're putting in place the structures and the groundwork, which means that whether I'm here, whoever's here, that this priority will continue, and that these recommendations and that this development will continue, and that we will see this reform and this change. In saying that, by saying this is laying the foundations, we don't want anybody to think for a second that there isn't a sense of urgency to this. Absolutely. There are people who need these changes yesterday, today, and who will need them in the coming weeks and months. So just to, I suppose, assure people that we're absolutely committed to making these changes through the strategy, through the bill, but above all to doing so with you, with your help and with your support. And that's why today is so important, and why I'm so glad that we have so many of you here with us. So I will leave it at that. Thank you very much for your time, and I look forward to all of the engagement that we have today. Thank you.
Thanks very much, Commissioner. The award of head transparency is going to Marshall Manners now for the panel discussion.
Thanks, Donegal. We're quite tight on time, and since Donegal already introduced the panel, speak for as long as you like. While I maybe give the Minister an opportunity to catch her breath, I might come to Angela maybe to begin with. There's obviously a huge change underway in the court service, a massive modernisation programme, a lot of changes during the pandemic. Can you talk to us maybe about the changes, particularly in the family law space, that are underway and how they're going to lead to improvements?
Well, I suppose the most immediate things that people will see is information, and even looking at the report today, children said that they wanted to know more about what was going to happen into the future rather than information being drip-fed as it goes along. So one thing we have done is to vastly improve the information that's available on the court service website. We've made it easy to understand, it's very clear, there are no big, there's no legalese in there. We've tried to keep the legal meaning, which is very important, on the various terms, but to explain them in a way that people would understand when you apply for maintenance, these could be the consequences. Because people didn't understand, it was very clear when we went out to engage with court users, that they didn't understand sometimes the consequences of making an application to court for one particular type of relief. Where there's domestic violence, for example, we know that an application for maintenance can trigger further events because it's an incendiary device almost to put into that family situation. So our entire goal is to make outcomes better for families. It's not just about, we've got a lot of money for investment in IT. So we have a new family law system being developed at the moment. It's about to pilot in 3 offices. That's on the internal side, and you go, well, what good is that to us and what good is that to children? What we'll do is provide us with data. Because at the moment our data is being collected manually around every office around the country. The district and the circuit court aren't even connected up in the same county. So we have different systems, different ways of counting things. It makes it very difficult for policymakers, for research purposes. It makes it very difficult for the president and for judges to manage their lists and for my staff. So that will help us. So information, data. Something we've done that didn't cost a lot of money was we rolled out trauma-informed training across all of our offices so that our frontline staff now understand, they can put themselves in the shoes of the person coming to the counter. That has made a huge difference. The feedback from our users is brilliant, but also from our staff, that it's made them stop and think. The use of plain English. All of our management teams spent 2 days last week doing 2 mornings last week doing plain English training. The members of the Court Service Board who are here would be delighted to know we use my CEO report to the board as one of the guinea pig documents. But that's really, really important because if you look at what children said, they wanted to be able to understand. Look at kids nowadays, they're going to be on the iPhone looking it up. They Google the process themselves, and we want the information that they receive to be correct, to let them know what's ahead of them, but to let them know in a way that's appropriate. So we're also going to look, as part of the strategy, we'll be looking at the information that goes to school children, for example. We have a programme for children to look at that information as well. And I suppose the last piece of the jigsaw then are buildings. And they're an average age of 162 years, so I'm not going to promise that we're going to make everything better immediately. But certainly, if you look at Hammond Lane, we used the research that Stephen and the rest of the family law reform team did to inform the design of the building. We use the approach that we're using for the entire modernisation programme, which is to go out and to talk to court users and find out what they need into the future in order to design that building. So I hope that it'll be a building that will be far more welcoming. Well, anything is far more welcoming than Dolphin House, but it'll be more welcoming. It'll be easier for people to do their business in because a building that takes the temperature down of proceedings where you're not sitting nose to nose with the person you don't really like as you're waiting to go in to make your application. All of that will help. And I suppose the final piece of the jigsaw then, and it's a big piece of the jigsaw, the Tradition Planning Working Group. On Monday I was in Tullamore and in Galway. Yesterday I spent the day in Sligo with our senior management team meeting in Sligo. And that is the #1 message that's coming through from our staff at this stage, that, I heard of a list in recent days, 270 cases, all family law cases, all listed. There's no reality to any of those being dealt with. It was literally to move the cases that had settled or needed a court order along. But that's, we can't continue to deal with cases. If you think back 50 years ago, there was no family law in Ireland. It was equity and it was about the land and the property. It wasn't about the people. We've now turned, through what we're doing and through the strategy, we're turning it around to make it about the families and the children and a better outcome for them. And I suppose, one thing I did forget on the information, this is the last bit. Our staff have also gone to mediation seminars with the staff of the Legal Aid Board in order to know more about mediation, to be able to, we're always going to have cases that need to go to court where people need a court order or need to see the whites of a judge's eyes. But you really need to be in court every second weekend to decide who's going to bring Johnny to soccer or something like that. So family arrangements, and to that end, we're looking at the forms to simplify those forms as well in that area. So there's a lot going on. That's the whistle-stop tour of family law at this stage, and hopefully it will improve things for children, because at the end of the day, both parents love their child and they want the best outcome for the child. It's just that they don't get on with each other anymore.
Donald said, I'm always impressed by the breadth of the course modernisation programme, so the fact that you managed to squeeze it into 3 minutes is very impressive. Judge Kelly, maybe if I could turn to you, the Minister obviously mentioned the importance of the review of expert reports that are on the way. They're obviously critical to getting the voice of the child, the issue facing the child, heard in court. Could you elaborate maybe a bit on some of the issues with the current system and how they might be addressed?
Yes, well, thank you. Initially, I think defining what expert is for the purpose of a child welfare or child voice report is an issue. There's a definition in the statutory instrument, which I think we need to look at again. I don't want to denigrate any particular category, but I'm not entirely sure that a teacher with 5 years' experience is necessarily possessed of the skills that are needed to deliver to a judge hearing a difficult family law case the voice of the child or views on the welfare of the child. So I think we need to look at the qualifications and the expertise of people who are being asked to deliver these reports. I suppose the more pressing issue for the courts that we would see is the availability of experts to provide reports. Many parts of the country, it can take 3 to 6 to 8 months to actually get a report. So of necessity, cases are being adjourned on a weekly basis to facilitate the preparation of reports. I was sitting in Dolphin House on Monday. I commissioned a couple of reports and I was told that it would be at least 3 months, if not more, before the report would start. It's a lengthy process. The reporter has to interview the child, has to interview the parents, has to come up with the report and put it before the court. So it's a lengthy process. It's unnecessarily long because there are waiting lists, there are backlogs in relation to the experts themselves. It has to be said that the fee structure for reports is a huge issue. A privately commissioned report can cost an awful lot of money. It's beyond the resources of most of the people that the district court sees in family law. The fee structure provided under the statutory instrument is just not viable, and the Legal Aid Board also has restrictions on the amount that it can provide towards reports. So they're all factors that feed into a judge having the right information before him or her in order to make an informed decision as to what is suitable for that particular child. Every single case is individual. Every single child has his or her own needs and requirements. So there's no one-size-fits-all approach. The quality of the reports is hugely variable. Some reports are excellent, well-researched, well-composed, well-drafted, clear recommendations. Others are brief, terse, clearly haven't had the necessary time put into them. So the quality of what's being put before judges varies enormously from expert to expert, from region to region. So I think there's a lot of work to be done. The fact that we now, as judges, have to actively hear the voice of the child in every single case involving a child, that's still a relatively new concept. It came into being following the referendum in 2015. And I think a lot of people, both practitioners and parties, are still getting used to that idea. There is a tendency to think of it as a bit of an afterthought, but it has to be front and centre with every family law case. And in order to make the case viable and to achieve the purpose for which it's intended, we do need to have a robust, high-quality system that is available within a reasonable time to families and to the judges.
Thanks very much. Maybe sticking with the voice of the child for a minute, Alan, if I could come to you, there have obviously been some recent changes to the guardian ad litem system. You might spell those out for us.
Okay, so I think it's really important maybe just to start with putting Ireland in the place it deserves to be with respect to the voice of the child. Internationally, Ireland will be recognised as a world leader in terms of bringing the voice of children into decision-making that impacts on their lives. And in the past 15 to 20 years, we've made enormous progress in terms of the collective voice of children and young people on what you might call mainstream issues. Actually, the first time I worked with Minister McAtee was on the voice voice of the child in youth mental health strategy. And even at that time, that would become very common practice for our department. And for a very significant number of child and youth service practitioners to bring that voice into their practice, into their strategy development and all the rest of it. And we moved from that collective voice on mainstream issues into really paying attention to more seldom heard voices, also on mainstream issues. But there's definitely a leap, I think, in terms of practice and methodology around the individual voice of the child and giving them a space, a voice, an audience and an influence on very complex matters like we're talking about here today. So I think it isn't surprising that maybe the reform of the Guardian ad litem system has always been on the horizon and something that we needed to do. But I think we have come to it at an appropriate time in terms of really having shone a light on the importance and the value. And within our own department, the Department of Children, and in our previous iteration, we were very specifically focused on children and young people. It has been practiced right up to principal officer at the minimum, and very often at assistant secretary level, to engage directly with children and young people very often. So myself, I would have led our structures on a Saturday in Regent Plaza, working directly with young people. And it never ceased to amaze on a weekly basis the innovation and the creativity that when you left that open space, the child's voice could bring to solving complex problems. Or you really have to commit yourself to going into a room, which isn't very common for civil servants, without knowing the answer you want to hear. And it's a really good faith in the process. So for us as civil servants and for practitioners across the system, that has been a real leap. I remember about 12 years ago when we did a consultation with children and childcare with respect to the Ryan report and where we would take the Ryan report. And 12 years ago, we met walls of resistance in practitioners who really did not want the actual child and young person to have their voice. They wanted to advocate on their behalf. They wanted to act as a kind of safeguard to the child and all the rest of it. 9-10 years later, when we went out on adoption proceedings, by and large dealing with the same group of practitioners, we had no resistance. So we have had a sea change. And I think that context is important to understanding where we're at with GAL. Getting back to the question you asked, we had, I suppose, a very high level of commitment to reform of the GAL in the, I suppose, pre-COVID period, where we did an extensive unit dealing with the progress on the legislation and another dealing with the establishment of the National Office. The legislation is now complete, and the Childcare Amendment Bill was completed last year, and it's ready for commencement. So and really that is a kind of, a major reform of the GAL system. It brings it all onto statutory footing, and it really will bring the benefit of the GAL system to the most, to a much greater group of children and young people. And we hope in a way to provide a consistency and high quality service. Speaking of, as the judge mentioned, that consistency and the quality of the service I think is really important. But also, I suppose, from the department's perspective, it has to be sustainable, and particularly when you want to increase the provision to that extent. So that legislation is now there, ready, if you like, to be commenced. So we're now very much under the work of my unit, turning our attention to prepare for the opening of the National Office and the National Service. And we have just this week completed a request for tender for an operating manual, if you like, and guidelines for the operation of the office. So I think where we're at right now is a very significant commitment by the department, having this reprioritised and moving towards the opening of the office. I wouldn't be in a position to give a specific timeline, but I can say it's now back. As was our department, we moved out of COVID, we've had the challenge of responding to the Ukrainian response, and now we're, I suppose, finding an even keel again and being able to reprioritise things. So I can say that we are now back with a very specific focus on it, and we will really be moving this forward.
Thanks, Olive. It's great to hear it's moving again. And just to acknowledge the support of your department indeed in helping us to carry out the consultation with children and young people defending the strategy. So
We have mainstream practice across both departments.
Yeah,
I think that's really, really important. Really not just symbolic, I think it has led to real difference in terms of what's in different strategies around their lives.
completely agreed. I want to come to Joan, and first of all, congratulations, Joan, on your appointment as the CEO of the Legal Aid Board. I understand the last meeting of the implementation group heard some developments in relation to child-centred mediation that the Legal Aid Board is working on. Do you want to tell us a bit about that?
Yes, absolutely. It's something which we are anxious to promote, and also for all the reasons that have been discussed by President Kelly in respect of the difficulties with Section 32 and 47 reports. We see this as something that would work very well for the voice of the child to be heard at a much earlier stage before we even get into court proceedings. The Legal Aid Board have a service mediation service which operates child inclusive policy and respect mediation. There's indirect child mediation and also direct child mediation, and I'll just explain that to you. Indirect child mediation is the child isn't actually in the room while the mediation is taking place, but the child's voice is brought into the room, and the mediator would have the experience of eliciting the child's needs in respect of the mediation process with both parents. So the child is put front and centre on what the child's needs are. And the object of that is to come up with a parenting plan that will work so that things like education, religion, health can all be discussed and agreed between the parents, and also to minimise the conflict situation with the child, to improve the relationship with other extended family members so they don't lose contact with their grandparents, for instance, whatever, and also to realise that there are now two distinct households and parents must be able to parent in that situation. And that is part of one of the things that mediators do, and at the end of that process they invite the parents to decide whether they wish then at that stage to bring the child in to the mediation process to explain to the child what the parents have agreed in a way that has no conflict, so that the child can feel confident that the parents have agreed this and both parents are going to abide by it. The other experience we have with children is that we have child inclusive mediation, and that is a situation where a child is actually brought into the room with a mediator with the parent present. Now, initially what happens is both parents have to agree that they are interested in pursuing this, and if they agree, they have to let her with the mediator that's very child-centred, with language that's appropriate to explain why the child will be invited into this process. And if that is agreed, then we have experienced mediators who are specifically trained in child mediation, and that's really important. It isn't every mediator who can do this. And we also have specific rooms, child-centred mediation rooms, in some of our co-located centres. And the reason for that is because it has to be child-friendly space. It has to have a wall of glass so someone can see in, and because you must have another member of staff other than the mediator available in the office that day to make sure that everything is done right. And it listens to, the mediator is experienced enough to listen to what the child's interests are, what their concerns are, what they're worried about, and can bring the child's views, and they do not interpret the child's views. They say it exactly as the child has said it back to the parents at the mediation session to explain how the child is feeling, because often parents might think they know what a child is going through, but actually they probably don't. I think as Olive said, you just don't know what a child is going to say to you. You really don't. Your parents can be really surprised at how children are feeling in respect to it. And it's a really good way of then bringing the family together where the parents make the decision, but the children have inputted how they're feeling. And it gives the parents a really good opportunity to make the right decision, the good decisions for the children. And normally I think you probably ask me how, what age we would look at as being appropriate. And we would say 7 years of age, probably there's a level of maturity onwards where it would be appropriate to bring a child into a room. But the important thing for us is that it's done with people who are, as I said, properly trained. They don't continue to be experts for the rest of the family law matters. So in other words, they're not child psychologists, they're not people who will be involved in hearing or anything like that, because they're not needed. Because at that point, the parenting plans are put into place. And people can always come back to mediation if it needs to be tweaked. It's not a forever thing, and that's important that people know that. But we have a working group now in the Legal Aid Board in our mediation service, looking at how we can develop this more, looking at what we can do to take the less adversarial road in respect of children. And one other thing, if you don't mind, I want to throw in as well, is that there's a very interesting project taking place in New South Wales at the moment in respect of childcare proceedings, which we're involved in and represent parents in childcare proceedings. And it is looking at a better way, and again it involves mediation at an early stage, where you have a situation where the three agencies involved in New South Wales in dealing with childcare proceedings proceedings, that's when children are taken into care, have come together in partnership on a pilot project to look at how they can come in, really work together at the very early stage before any child is taken into care, to see how they can work together to put in place processes, procedures, simple things that maybe they can work together at that stage. And they also have an ADO or a mediation service available just to try and deal with situations that might arise where a child might end up in care unnecessarily when early supports aren't put in at the very beginning and the two agencies are working together. And I know they're amending their legislation in that respect, within the legislation there in October. And I think it's a really interesting way for us to look at it, because we have actually been involved in the mediation in childcare proceedings between a situation where a relationship is broken down between a social worker and parents. That can be extremely fractious. And I think as President Cameron know, you can end up in court umpteen times on a simple situation, which has no need to be in court at all, and mediation can play a part in that. Now, the one, I suppose, health check I put into this is that we don't have mandatory mediation in this country, and so we can't force people to go into mediation. But it is extremely successful in many ways, if for no other reason than setting out what the issues are, so that both parties know what does the other party really want here. It isn't all conflict. And that alone is exceptionally helpful to reduce stress levels, to reduce the length of proceedings. And I think that it's absolutely imperative that we look in that direction, and we're committed in the Legal Board to promote this. We have a working group in place to do that. It does take, we're looking at perhaps having a specialist expertise in it particularly, and also, of course, to support educators and their well-being in this process as well. People will be training and support. But I think certainly the project that I mentioned, New South Wales, is very worthwhile. Something that maybe we can consider here in this jurisdiction.
Thank you very much. We're tight on time, and I want to get to a couple of questions from the floor. Just before I do, I want to come back to you, Minister, if I may. In your own speech, you obviously set out a lot of detail on the actions that are underway, and the panelists have been adding to that. Can you maybe lift us back up a little bit and give us a sense of what your vision of what all of this will amount to is going to be?
Yeah, I mean, if I could just touch on something that Angela mentioned, and that is that it's not that long ago that we didn't have family law as we see it or apply it now. And certainly we didn't have a situation where a child was deemed in any way necessary or to be part of the whole process. So the very fact that we've come as far as we've come over here now is a huge positive, but it does mean that we do have to lay all the foundations that I mentioned earlier. So we have a lot of work to do. Again, I stress the will is there, the desire is there, people are here to actually bring about that change, but when you have to put those foundations down, when you have to invest in the infrastructure, invest in the IT, put in place new regulations, when you have to develop new legislation, all of this takes time, but I would bring it back to the individual cases that I think of, people that I know, the family members that I know, the challenges that I've seen where there have been children involved, where there were no children involved, where situations have gone on for years, where they have been addressed quickly, and I think how could we make those situations better? And that's my overall goal and objective, and it's not one thing, it's not one change, it's a whole suite of changes, and as Angela Douglas have rightly pointed out, there's a lot of work happening, so we're laying the foundations, there's work happening in parallel, we're implementing this strategy, but to take it back to the higher level, it's all of those cases that we can think of, the families we've engaged with, if all of this was in place, would it make their lives and would it have made their scenarios that little bit better? And I think if we can implement all of this, and probably more, and some that won't work, and things that will move and change, and like anything, it needs to be a living, breathing strategy and plan and action. If we can implement all of this, then I believe that actually those scenarios and things that are coming down the line that we will be able to improve what is a really difficult scenario for them. So that's my goal and my objective, and taking it down to the simplest form. It's not straightforward, but as I said, there are so many people here that are absolutely committed to it, that I
advantage of time, so I'll be brief, but I do want to just acknowledge not just what the Minister has set out, but also what all of the representatives of the different statutory stakeholders in terms of the breadth and the scope and the depth of the work that is ongoing. It is unprecedented, and I'm the CEO with Women's Aid, and from our perspective, this multifaceted approach could not be more welcome, and we're very committed to supporting it. I just a question probably for Donnacha in the main, but perhaps Angela might say something as well. We really welcome the trauma-informed perspective that's been brought to bear in the courts, and conscious as well that the Family Courts Bill has already gone through its pre-legislative scrutiny, and the strategy itself then is a supporting vehicle for that. When we are, recognising, I think a statistic that came up at our own seminar last week is that on average at least 60% of all cases that process through the family law system will have some form of domestic violence as a factor. Just as that legislation is being finalised, just how that reality of the fact that domestic violence doesn't just, and specifically coercive control, doesn't just show up in domestic violence proceedings but actually permeates the whole system, just how that might be made more visible, but either in the legislation or the strategy itself. And then just a very practical question, which I know I won't be alone in wanting the answer to, and just on a practical basis, the examination of the report system, which the Minister has commissioned as part of the work underway. Just very interested to know what in broad strokes the terms of reference will be for that, and whether there will be a consultative component to that, because obviously there's many different stakeholders that have an interest. Thanks.
Thanks very much, Sarah. Before I come back to the panel, we have a second question here. That's okay.
Good morning, Minister. Good morning, panel. Thank you for the invitation from the Department of Justice. I'm the chair of the Irish Professional Mediators Organisation. I'm Roisin O'Shea. My question is for Judge Kelly. Where proceedings are already in being, and say it's Section 16 referral to the Mediation Act mediation, and in the mediation space a parenting agreement is reached, and the mediator engages in child consultation, so direct consultation with the child, hears the child's views, and the parenting agreement comes back in. Would that satisfy hearing the views of the child from the district court perspective? Thank you.
Judge, you want to take that straight away?
Yeah, I think it would, yeah. Obviously it will depend on the context, but in broad terms, once the child's views have been made known and put before the court, in that context, there's an agreement coming to the court, and the court will be asked to approve or make it an order. Generally speaking, we let the parties come to agreements if they wish to do so. We get involved in making decisions or making orders where there's a conflict or a conflict to be resolved. If there's no conflict to be resolved, I think that would satisfy most of us.
Donnacha, do you want to take Sarah's question?
Yeah, sure. Thanks, Neil. Thanks, Sarah. A couple of aspects there, all very important concerns and perspectives. Certainly there's a very strong sense in which we need to ensure that the various strategies we have, and we've just spoken about a number of them, which are all very good, but we've in good place in terms of improving access to justice, improving outcomes for victims and other court judges, that they are all drummed up. And we've heard that message very strongly, and it's a key focus for me in my role. Insofar as the legislation is concerned, I think we've had some good suggestions as to how we might write that into the principles underpinning the legislation, and it's certainly our intent to take that on board. And I suppose the activity then follows the principles you would expect, because those are the principles by which the system will be built on, and that's really important. I think when we turn increasingly now to look at, and it's a piece of work which we're kicking off around the training requirements around the system. There's a big focus on traditional training, but it's a cross-cutting training requirement, and clearly the perspective and the experience that people have brought to us around the use of trauma-informed approaches will clearly feature in that, I'm sure. On the expert report, as the Minister said, the Minister asked to bring forward that work. So we've had to rejig the strategy a little bit, but on my timeline, we aim to have output by the end of this year, and I expect that we'll be engaging with people around the system, around their experience with that, and we'll touch on the various issues that the judge has referred to. So there's a panoply of issues, including qualifications, the statutory scheme, and frankly, the money as well, of course, because clearly the judge identified that as a factor in that. So so I think one of the big messages I think we have is that we're in a really good place. There are a lot of things happening. We need to try and make sure that they're all happening in concert, and we're actually taking a combined outcome for everyone's best outcome.
Just add very briefly to that. Sorry, just Sarah, I think it's important to note also that Maria Mosquirty, the Director of Judicial Studies, and Marie Fitzgerald, the Associate Director here, trauma-informed training is also being provided to judges, and not just court service staff. I think that's very welcome and important development.
From our perspective, I suppose at the moment, the current core system in the district court actually does help address some of the problems, because the same judge is very likely to hear a family law case as will hear an application in relation to breach of a barring order, because the two are often mixed in the same list, unfortunately. And I suppose something we do need to pay attention to into the future, and I was glad to hear to look at the in-camera rule, is how that sits with coercive control, the issue of coercive control, and how we weave that through the family courts bill, just to ensure that we don't accidentally block stuff out, because at the moment we have that mixed list in the district court, so the judge is very likely to see the offender, shall we say, both in the family law list and on the criminal side of the house. But once we separate out our family law hearings from criminal hearings, how does that information get across from one side of the courts to the other? And I think that's something we will have to watch out for. But I think it's about building understanding. It's about building awareness. It is about training, both for my staff, for judges, for everybody who's in the courtroom, just to know what to look out for. I think that's really, really important.
Thanks very much. I'm going to give you the final word now in a second. I was given very strict instructions. We had a hard deadline of 11 a.m. It's 11:01. So and the reason for that is firstly to allow the Minister to go over to the Oireachtas, which is due, and then secondly to give enough space for the breakout sessions that are planned. So to wrap us up, Minister, with the final word.
Just on that final point from there, obviously the bill has been worked on at the moment, and there's a lot of policy decisions have already been agreed on. But as we can see, there's lots of other areas where something new might arise. So, as is the natural course of the bill going through the houses, the committee stages, there'll always be an ability if we need to strengthen certain areas to do so, and to improve language, to change it, and to make sure that exactly what you're saying happens.
Thanks, Minister, and thanks to the whole panel. We're going to break for tea and coffee for a few minutes and then regroup in the breakout sessions.